Registering shares for IPO and sale to the public. This lecture provides an introduction to the process of registering shares as part of an IPO or public sale of securities. The sale of securities is highly regulated by the SEC. It's important to understand that the definition of a security is very broad. It covers the more obvious candidates such as company shares and options. Bonds and other forms of debt are also classified as securities, except short-term loans, mortgages, and other notes that are explicitly excluded. But you don't need to sell stocks and bonds to find yourself selling a security. Any investment contract involving the investment of money in a common enterprise with expectations of profits solely from the efforts of a third party qualifies as a security, and this can cover a wide range of business activities. Even lawyers are often caught out and found that they've inadvertently transacted securities and triggered the federal laws. The basic rule for selling securities is that they must be registered with the SEC or they must qualify for a valid exemption. Whether it's inadvertent or not, selling unregistered securities can be very costly. The law allows investors buying the shares to rescind the sale. This means the company or bankers paying them a full refund. The prospect of returning all the funds raised from investors is not very appealing to most companies, so they generally look to register or qualify for an exemption. The most obvious upside of registration is that it allows the company to raise funds from public investors. Registration is also a step in the process of founders, venture investors, and other shareholders selling their own holdings of company shares. There's no doubt that a dazzling IPO can have a positive effect on the company image and help generate positive publicity. Publicly traded shares often provide currency to take over other companies and facilitate growth through acquisition. But there are downsides and costs to registration. The underwriter generally takes around 7% of the funds raised. With legal, accounting and other fees, the total cost of registration can run to around 11%. And this adds up when the average IPO is more than $200 million. The costs and burdens do not stop when the funds are raised. Ongoing reporting to the SEC and the new Sarbanes-Oxley auditing regulations have pushed up the costs related to being a public reporting company to several $1 million a year. Sarbanes-Oxley and the other regulations expose public companies to huge liabilities and other potential penalties for missteps. Registration is usually a one-way street. Deregistering is very difficult as it's only available to companies with less than 300 shareholders. Whittling the shareholder list down to less than 300 is not easy following a public offering, so most companies that register continue reporting indefinitely and bear the associated costs. Following an IPO, a company is required to report by the SEC. After registering its securities, the issuer becomes a reporting company. However, reporting can be triggered when private companies grow large. All companies with more than 500 shareholders and $10 million in assets are required to report. Google was sanctioned by the SEC when it passed through this threshold and inadvertently failed to start reporting. Of course, a company can voluntarily start to report to the SEC. This may be done to send a signal that it takes disclosure very seriously or to pave the way for a future public offering. There are several steps in the registration process. Starting to discuss a public offering with an underwriter puts you in the pre-filing period. This is when you start to prepare the registration statement. Once you've filed the registration statement with the SEC, you're in the waiting period, waiting for SEC approval. This is when you visit potential investors face-to-face to solicit interest. When you have sufficient interest from investors and the SEC and National Association of Securities Brokers have indicated their approval, you're in position to set the share price and sign the agreement with the underwriters. Then all that's left is for the SEC to declare the registration statement effective. You're now in the post-effective period. Shares are being sold and traded on public markets. In the pre-filing period, it's important to prepare the registration statement and the prospectus contained very carefully. Mistakes can be very costly later on. You're not allowed to make any offers of securities during the pre-filing period. What constitutes an offer is very broad and includes communication that can be interpreted as conditioning the public mind or arousing public interest. There are safe harbors that allow the company to continue its regular sales and marketing activities during this time. Large, well-known seasoned issuers such as Microsoft or IBM are allowed to communicate with potential investors through internet and other writings if they meet certain criteria, such as referring potential investors to the prospectus. After the registration statement is filed with the SEC, you're still not allowed to sell or make written offers to sell securities. But you are allowed to circulate the preliminary prospectus and make face-to-face presentations to potential investors. After the registration is declared effective, it's important to deliver the prospectus to buyers at the public offering. Since 2005, the delivery of the printed prospectus by snail mail can be replaced by a posting online. Investors are assumed to have online capabilities, and access to the information online is considered the equivalent to delivery of the printed prospectus. However, they can request a hard copy if they prefer. If one buyer doesn't get a prospectus when she should, all the investors in the public offering can sue for rescission of the sale and demand a full refund. So the failure to deliver a document costing a couple of dollars can force the company to refund the whole proceeds of the IPO, and that usually runs to several $100 million. Follow-on offerings are much quicker and easier than the IPO. The S3 form takes only around 20 days to prepare and less than 10 days to become effective. Large, well-known seasoned issuers such as Microsoft and IBM can now take advantage of shelf registration. They can register securities now for sale during the upcoming 3 years. They're no longer forced to sell the securities immediately following registration. The number of shares offered does not have to be specified in the registration of the base prospectus, and is provided by the company in a supplement when it decides to go ahead and sell the securities to the public. Shelf registration provides mature issuers with the flexibility of holding registration statements on the shelf for several years. Triggering the offering can then be very fast and painless. So when you find yourself selling a security, you must register or find an exemption. The registration process takes months, and the costs of IPO and registration are significant. But follow-on offerings are faster and less costly. Gun-jumping rules prevent hyping in the capital markets. Shelf registration is now available for larger issuers. Once you're registered, you're forced to continue to report, and reporting companies are subject to costs, liabilities, and strict regulation.